Okay, the final case of the morning will be RESTAL versus NOCERA.
Good morning, Your Honors. May it please the Court. Angela Flowers on behalf of the appellant defendant below, SHAWN RESTAL. I would like to reserve 5 minutes of my time for rebuttal.
All right, you may proceed.
Defendant is here asking this court to reverse the final judgment and remand for a new trial based on two harmful errors that occurred below. First, the trial court entered a summary judgment on liability against defendant based upon the rear driver presumption. This summary judgment ruling was error because there was ample competent evidence in the depositions of both the defendant and the plaintiff, which indicated that the plaintiff contributed to the accident, as well as evidence which the jury could have relied upon to determine that the plaintiff was 100% at fault for the accident.
Could you point exactly to what you're referring to as far as that evidence?
Yes.
In the depositions.
Yes, I would like to go through some of the various statements that appear in the deposition. There was evidence regarding the manner in which, and I'm happy to give you some record sites, but let me just go through a description of what the plaintiff and defendant testified to. So the plaintiff had entered onto Emerson, having to make a right-hand turn, even though she needed to go the other direction. So she testified that as she turned right, her goal was to find a place to turn around and make a U-turn. Defendant was traveling in the inside left-hand lane, headed in the same direction as the plaintiff. Eventually, the plaintiff pulls over in front of him because she sees that there's a break coming up, a median in the road. The defendant testified that he had between 3 and 5 seconds of notice at the time that she pulled over in front of him. She admitted that she was pulling over looking for an opportunity to make a U-turn. He testified that she pulled over in front of him. He had 3 to 5 seconds. She slammed on her brakes and that he was not able to avoid the accident. She testified that she pulled over in front of him and slowed down to evaluate the median area. She admits that she never put on her blinker. She claims that she never touched her brakes, and she indicated that once she saw that there was a no U-turn sign, that she abandoned the idea of making the U-turn. Defendant, in contrast to that, testified that the plaintiff initiated the turn to go into the median, and then that she aborted it and pulled back out into the traffic. And you will find these statements beginning on pages 5372 of the Record on Appeal, and with the defendant testifying there on deposition, traveling all the way through 5384 of his deposition.
Now, your client didn't see, the defendant didn't see the plaintiff change lanes, correct?
The defendant admits that he didn't see the plaintiff until she pulled in front of him.
Well, he said he didn't see her change lanes to be in front of him.
Right, he saw her, right, she was not in front of him, is what he testifies to. And then that he first sees her when she pulls in front of him, and there's about 3 seconds before she slams on the brake. The plaintiff's deposition testimony recounting these events begins on page 5303 and travels through page 5314. So there was ample evidence from which a jury could determine that from the defendant's perspective, the plaintiff pulls in front of him, goes to pull into the median to make a left-hand turn, and then changes her mind, pulls back in front of him, and because of her slower speed, causes the accident.
Well, let me ask you this. Are you challenging the trial court's determination that your client was negligent as a matter of law? I mean, leaving aside the comparative negligent issue, are you challenging the trial court's determination that your client was negligent as a matter of law?
We are challenging the determination that the defendant was 100% at fault.
Right, but you argued, when you first got up here, you said that a jury could find that the plaintiff was 100% at fault, which to me, was a little different than your brief, because your brief, I took it as you were only challenging the trial judge's decision on comparative negligence. But if you're saying that the jury could find 100% liability, then are you saying the trial judge was wrong for granting summary judgment on your client's liability?
The brief,
your client's negligence.
yeah, the summary judgment order contains 3 rulings, and the brief challenges 2 of the 3 rulings. The first ruling is summary judgment on causation for the accident. The second ruling is summary judgment for causation of the medical injury. And as we argue in the brief, we're seeking to have summary judgment as to medical injury causation reversed as well, because there do exist some facts from which the jury should have the opportunity to determine whether or not the plaintiff was 100% at
As far
fault.
as the negligence,
Yes.
who caused the collision, are you challenging the trial court's determination that your client was negligent as a matter of law, leaving aside the comparative negligence issue?
Yes, there is conflicting evidence within the record from which a jury could determine that, in fact, plaintiff was driving haphazardly, pulled in front of defendant, sought to make a left-hand turn into the median, which would have permitted the defendant to have passed by her if she had continued her entry into the median.
The client's own testimony was that he was a half to 1.5 car lengths behind while going 35 to 40 miles an hour, and that the plaintiff's car was in front of him for several seconds. I mean, to me, that right there is an admission of fault. I mean, may or may not be 100% fault, but, when you take your driver's test, it's always a question on, they emphasize 1 car length per every 10 miles an hour. I mean, he's not even close.
Well, a few things. First of all, his actual testimony was he's going 34 to 35 miles per hour in a 40-mile-per-hour zone. And as for whether or not a car length and a half, which would be how you would read his testimony most favorably for purposes of summary judgment evaluation, and whether or not that would have been sufficient had the plaintiff completed her turn into the median, perhaps may be an issue for a human factors expert to testify to. But at that stage, what the trial judge granted summary judgment on was the rear-end driver presumption. Summary judgment is only appropriate on that basis if the defendant is 100% at fault. Once the defendant comes forward with any evidence that the plaintiff was comparatively negligent, it is inappropriate to grant a summary judgment based on the rear driver presumption. So there should not have been a summary judgment in this case, which would have left the issues open to go to trial, to be tried on the direct and circumstantial evidence, and for the jury to determine who was at fault and the degree of fault attributable to each party. It's simply more of a textbook argument at this point that the trial judge could not grant summary judgment on the grounds that were presented to him, which was an argument that the defendant was 100% at fault. And if he couldn't grant summary judgment on that basis under the rear-end driver presumption, then he also could not grant summary judgment as to medical injury causation. For those reasons, the summary judgment improperly deprived defendant of his defense in the case and his opportunity to put on a comparative negligence argument. And as the Supreme Court discussed in the Burge versus SHAWN case, the comparative negligence statute, 768.81, is preeminent over the rear driver presumption, which is a judge-made rule geared to addressing certain evidentiary situations. But where there is evidence that the plaintiff was a contributing factor to the accident to any degree, it's no longer appropriate to grant summary judgment based on the rear driver presumption. The second harmful error that occurred during trial was that the trial judge gave a Stewart versus Hertz jury instruction. The plaintiff was the first party to introduce testimony at trial from Dr. Schumacher, who was defendant's expert CME witness. Dr. Schumacher testified that unlike the plaintiff's treating physician, he did not observe a herniation at the C5-6 level, which was the area that plaintiff's treating surgeon ultimately performed surgery on. He testified that he did not observed this condition, that there was no causal link between the purported injury and the automobile accident, and he disputed the wisdom of the diagnosis. Plaintiff, as I said, presented this evidence first, and that would have been on page 834 of the trial transcript. The evidence that
Ask you this, was there any testimony, because I don't recall, was there any testimony that the plaintiff's injuries were aggravated by the surgery? Or
No,
just that
there were not. No. Dr. Schumacher, in fact, confirmed that the surgery was successful in terms that the plaintiff was no longer suffering any pain that she had indicated that she experienced before. So there was no question about the choice of the surgery if, in fact, plaintiff's treating physician observed the herniation that he said he saw. So the selection of the surgery wasn't disputed. There was no argument that the surgery made her condition worse. It was simply testimony concerning the causal link.
Let me ask you this, and the fourth I don't think really discusses it in their cases, but can a jury find that a plaintiff suffers pain and suffering by going through a surgery and the time after the surgery? Can you award damages for the pain and suffering incurred as a result of undergoing and recovering from a surgery?
Absolutely. And what that goes...
All right, so if the defense takes the position that the surgery was unnecessary, should the jury be instructed on, even if it's unnecessary, the plaintiff is still entitled to recover those damages?
Well, the jury,
assuming that there's causation and negligence, et cetera.
the jury will receive such an instruction. This testimony concerning causal link is the threshold
Well,
issue.
how does the jury, but isn't that the instruction that we're arguing about here?
No.
Because what if if the jury finds, well, that surgery was unnecessary, so we're not going to give any money for pain and suffering incurred as a result of that surgery, that would be an error, right? Because the case law is that, if you have that pain and suffering from malpractice or error
In most
or whatever,
instances, although we have seen cases where the plaintiff's
the fourth talks
recovery doesn't...
about discusses improvement in the condition of the plaintiff or worsening of the condition, but I'm asking about the pain and suffering, which they don't really discuss.
The Stewart versus Hertz jury instruction is titled Other Contributing Causes of Damages. And it is instruction that follows after the instructions where the jury is directed as to how to determine whether or not the accident caused a particular injury. It's after the accident is found to have caused a particular injury that if there was an intervening cause which caused additional injuries, that you give a Stewart versus Hertz instruction. The question you're asking, from a practical standpoint, it doesn't come into play for the jury because they've already made the causal...
If the jury found that the surgery was unnecessary, they accepted your expert's testimony on that, and that the plaintiff nonetheless suffered pain and suffering from undergoing that surgery and from recovering from that surgery, as a matter of law, would the plaintiff be entitled to recover for that pain and suffering, assuming that, the jury found some liability on the part of your client?
If the jury found in favor of plaintiff, the jury would be finding that there was no causal link between the contested accident and the injury that plaintiff's treating physician observed and the surgery that the treating physician performed on that basis. That's a causal link question. And so the jury would have never they would have been instructed on damages, but they would have never reached that issue because they would have made the determination at the causal link stage. And that's what this evidence goes to, whether or not the jury is going to determine that the accident caused an injury. So this doesn't go to the idea of what's involved with Stewart versus Hertz, which is whether or not the jury has found that the accident caused an injury, and then there's some type of argument made by a defendant that, well, there may have been one injury, but we shouldn't be responsible for any subsequent harm, malpractice, exacerbation of the injury that was caused by a treating physician taking action he shouldn't have taken or taking negligent action. So the Stewart versus Hertz instruction is all about an intervening cause where there's
Well,
additional
performing
injury.
unnecessary surgery would qualify, wouldn't it, as far as an action by a subsequent medical provider, which made it worse for the plaintiff?
Well, you're
Maybe
indicating-
not their permanent physical condition, but at least for a while.
Well, we're calling it unnecessary because we're recognizing that the jury already made a threshold determination about causation. And that's why you see not only the bulls.
Was the impetus of your expert that disputing that there was any injury as opposed to disputing whether or not a surgery was required?
The defendant's expert did not dispute that there had been some injury suffered by the plaintiff by way of soft tissue injuries that with conservative treatment had resolved within 8 to 12 weeks. And the defense expert conceded that. What the defense expert and many of the other doctors, including some of the treating radiologists, did not observe these herniations on the films. And the treating doctor was testifying that he didn't observe this particular herniation injury. And then because he did not observe this injury, that he would not have performed surgery for something he didn't observe. And again, the plaintiff introduced this evidence. As I said on page 834, they invited this information, this testimony into trial. The charge conference was held prior to the defense presenting their case in chief. Plaintiff never asked for a Stewart versus Hertz instruction, even though they had just put on this evidence. Then the defendant put on his evidence, and the plaintiff asked that the additional instruction be given. That was error on multiple levels. First of all, because the testimony did not cross the line out of causal link testimony, it did not become malpractice testimony or testify that plaintiff's condition was made worse. And in addition, it was invited by the plaintiff by having first introduced the
I'm just going to tell you down at
testimony.
335, just so you know.
Correct.
Okay.
Finally, regarding the proposal for settlement argument, with recent developments and the Supreme Court's reversal of Nunez versus Allen, it has diminished the defendant's reliance upon that case in the particular briefing that's presented to the court. The defendant at this point is going to rely on the briefing of these issues and would point out that there are still distinguishing points between the arguments made in this brief and the issues that were addressed in the Nunez decision, and would additionally point out the defendant's argument that there's an invalid condition in this particular proposal for settlement having to do with placing the burden on the defendant to indicate if there are any ambiguities in the proposal for settlement, and that alone would invalidate the entire document.
Okay,
I'll
thank
save the
you.
remainder of my time.
Good morning. May it please the court, my name is Chris Carlisle, and I'm here on behalf of the appellee, BRIDGET NOCERA. Your Honors, turning to the first issue, we didn't hear a lot of discussion about the presumption and the Florida Supreme Court case law that deals with that, and I think it's critical for the court, obviously, to look at Clampett, and it talks about the presumption can be overcome by a substantial and reasonable explanation. We're talking about the facts of this matter were, at best, taking it most favorable.
In Clampett, subsequent to Clampett, the Supreme Court said, we may have, been a little confusing in our Clampett decision, so we're saying this now. So, in Cervalos, I think it is.
That came from this court and went up there. I think the issue was,
Well,
again,
Cervalos, our case from our court was Burge versus SHAWN, and that went up the same time as Cervalos, and the Supreme Court did opinions on both cases, I think, the same day. But, Cervalos said that if you put on evidence of comparative negligence, then then it talks about whether the presumption applies at all.
right. And the question becomes, what is the record evidence in this case? And obviously, that's the thing we need to be looking at.
But if there's evidence of comparative negligence, does the presumption apply?
What is the evidence of
Well, I'm
comparative
saying,
negligence here?
that's a separate issue. But if there was evidence of comparative negligence with a presumption of rear end, the rear end driver being negligent, even apply in this case?
I think, Your Honor, then you talk about, when we talk about the exceptions to that, and what are the categories of that, and we talk about stopping short, and I'll get into those cases in a minute also. But what are we talking about here, and how does the presumption arise? Taking in the light most favorable to the defendant in this case, he was a car length and a half behind, and I think the critical thing that occurred here, which the court needs to recognize and did not discuss, was, again, his own admission. Could he have avoided it if he left more distance? And he said yes. The trial court focused on that. He's a car length and a half at most behind, going 34, 35 miles an hour by his own testimony, which are the critical facts here. So we're not even getting into these other bits of evidence on that. I could have avoided this, and we talk about clamp it at a time and a place where it cannot be reasonably expected. I'm going to get into the sudden stop issue, but also—
Let me go back
Yes.
to my question.
Yes, sir.
Okay, I'm reading the Supreme Court's language. They say, accordingly, we also held in Burge that where evidence is produced from which a jury could conclude that the front driver in a rear-end collision was negligent in bringing about the collision, or that the negligence of the rear driver was not the sole proximate cause of the accident, the presumption that the rear driver's negligence was the sole proximate cause of the collision is rebutted, and all issues of disputed fact regarding comparative fault and causation should be submitted to the jury. So my question is, and I know we have to decide the question whether there was fact evidence that would support submitting comparative negligence to the jury.
Right.
But if there was evidence in the record of comparative negligence, does that mean the trial judge erred in relying on the rebuttable presumption of negligence by the rear driver?
I don't think so, Your Honor. I think, again, that there's talking about different things, and there's an interaction between the categories that have occurred in the past and the sudden stop doctrine, which is what their defense was here, versus other cases where there was an abrupt lane change or something else. And I think that the law still remains that the cases involving a sudden stop would apply to this case as their only defense. You have him admittedly following too close behind. You have clamp, which is still good law, talking about how to overcome the presumption in that circumstance. And one of the ways you can do it is the sudden stop doctrine. But even if you get to that point, it talks about how it has to be at a time and place where it wouldn't reasonably be expected to occur. And what are we talking about here? The Epler case from the Supreme Court and then Clampett, Epler was a situation where it was not reasonably expected to occur. Clampett, they reversed on a summary judgment issue saying it was. What do we have here? We have the admission that he knew the road, that you could make a left-hand turn there, and it's entirely reasonable for a car to be slowing down in order to make a left-hand turn. Whether or not the U-turn was perceived or done or not, they still, by their own admission, knew this. And the long line of
You have a car in
cases.
front of you, and it's you're following behind, and the car, goes over the lane because they want to make a U-turn, and they say, "Oops, there's a no U-turn sign." They get back in.
I don't believe the evidence indicated that. I think it was the car was in front of him in that lane and never made it into the median.
But just go on my hypo. What about that situation? They're going
think-
over and they see, and they're like, "Oops, no, I can't make a U-turn there," so they get back.
I think there is
Sure,
some evidence, and potentially based on a certain case, and there are cases talking about a sudden swerving into a lane or something else, but that's not what we have here. And again, when you have the body of case law from Clampett onward talking about a reasonable safe distance and the burden being on this person, and you're talking about, the fact that the driver behind has to reasonably be expected, he has to reasonably be expecting that these things might occur. And every bit of evidence in this case, it's not enough to say that there was a tiny distinction, or also should the defendant in a given case get the benefit of the doubt when his testimony is all over the board on these type of things and say, well, we created a factual issue. The critical testimony, which is undisputed, is him being at most a car length and a half behind, going 34, 35 miles an hour, and acknowledging that if I wasn't following so close, this would have been avoided. That was the evidence that was before the trial court, and on that evidence, the court granted a summary judgment. And there's frankly no dispute about that. And if we want to talk and nitpick about certain minor errors or minor discrepancies in the defendant's testimony and his deposition, it doesn't impact those critical issues, which are what the trial court focused on in the order. And again, how do you get around a rear driver saying, if I wasn't following so close, this wouldn't have happened or this could have been avoided? And that was the end of the story, and the trial court didn't err in making that decision. Concerning the other issues, as far as the causation, as far as the medical things, I've not really heard much argument besides, well, because the causation on the accident was wrong, that can't follow from that. We pointed out, and the trial court acknowledged in its order, that the only evidence that was before it when the summary judgment was there were 4 doctors from the plaintiff's side saying that he suffered an injury as a result of this accident, and you have Dr. Schumacher saying exactly the same thing, the CME expert. There was nothing else in the record to say that there was anything different that flowed from that, and therefore the summary judgment on that issue was appropriate also. Turning to the jury instruction.
Was there any, I mean, I'm having some concerns with the jury instruction in
Yes, Your Honor.
this context, because typically you see it when there's been an exacerbation of an injury and their medical malpractice, but that, I don't see that was at issue here, that this was a question of whether we saw this injury and this doctor said we had it, so it would have been okay. I guess if there was that disc problem, it would be okay to have that surgery, but this doctor said I wouldn't do the surgery because I didn't see the problem. Was there any sort of exacerbation of injury or anything like that that you typically see when this instruction
I
is
don't
given?
believe there was, Your Honor, but 2 things on that. Number 1, the reading of the case law and the jury instruction, in our opinion, doesn't necessarily require that, even though, as you're right, maybe typically that sort of happens. But going also to Judge Evander's comments, if I'm saying this was unnecessary and therefore it was malpractice, and the Nason case says Florida law recognizes that unnecessary surgery may constitute medical malpractice when it deviates from the standard of care. So you have that, and then you have this extensive testimony that it was unnecessary. You have the one surgery, then you have a future surgery. You have a jury instruction that says if this guy or this defendant was responsible for the accident, he's also responsible for any additional loss, injury, or damage caused by medical care or treatment reasonably obtained. Therefore, again, the pain and suffering that could potentially flow from that, and also the damages for the additional surgery. When the jury has an issue before it about future medical expenses, that jury instruction goes to that, and therefore they can do it. But an additional point, Your Honor, the argument, and again, I know, as you said, some of the cases talk about, yes, there were exacerbations of injuries. Is there a bright line that that's required? I don't believe so. But perhaps more importantly, that argument was never made to the trial court, and the trial judge never had the ability to even consider that argument. You have this discussion which takes place when the jury instruction is given or requested. You have a motion for a new trial. At not one time did they say, you know what, you can only give this instruction in the event that there's an exacerbation or something else that occurs there.
Is there a case where there isn't an exacerbation that this instruction that's been used?
Your Honor, I think in Nason, it talks about it, and there was some language in the facts of Nason which can be read that way, but it's not saying this is a bright line, you have to have it in all these cases. And furthermore, I would think that if that's the argument that was made, and if this was an open question of law asking the trial court to decide, and the court reads Nason and says, I think it's on point, I think it was their obligation to come forth at that time on this discretionary decision whether or not to give a jury instruction and say, Your Honor, we'd like to preserve our argument that maybe there's an open question about whether or not the exacerbation is required. They didn't do that. And again, frankly, I think that given the jury instruction, which doesn't require and doesn't discuss the possibility or the necessity of exacerbation of a thing from that, and further going to the idea that it talks about future damages, which certainly could be future medical expenses, and also, as Judge Evander said, could be future pain and suffering from this, I don't think it's required. And again, it's a discretionary decision by the trial court. There's not a case that says that is required, and certainly the jury instruction doesn't require that. So given all that, I think that the jury instruction was appropriate in this case. And you look at those cases, and I would further throw in that they made such an issue of this in their closing, which is similar to the things that occur in a variety of these cases, where they're just disparaging the doctor and impugning him and saying, this guy wanted money. This was completely unnecessary. He saw $700,000, and they repeated that over and over. And if you look through a few of these cases, the fact that counsel makes an issue of this also and impugns the doctor's integrity goes to this issue and also justifies the jury instruction being given in those circumstances. Finally, on the proposal for settlement issue, as counsel acknowledged, there's a waiver issue there also, and we didn't hear much discussion about the PFS. The trial court was given one argument on this that occurred at the hearing where the defense said, based on the Nunez versus Allen case, we think that the proposal for settlement is invalid. Well, that argument is now gone based on what the Supreme Court has done. The other arguments that were raised in the brief were never raised below. Frankly, I don't think there's much to them, given the Supreme Court talking about over and over now how the nitpicking needs to stop. And a fair reading of this PFS shows that the defendant was designated in bold letters that it was being made just to him. If they paid the money, the case was going to go away. So the other arguments concerning the PFS were waived. To the extent the court wants to consider them, I think the PFS can only be read in one way, and there's no ambiguity whatsoever. It's not even close to being what occurred in Nunes versus Allen, where you had 2 paragraphs that allegedly conflicted, and the Supreme Court even came back and said that's not enough. We don't find the ambiguity there. So I think on the PFS issue, again, to the extent that any argument was preserved, it was a Nunes versus Allen decision or argument that was made below, and that is now no longer at issue in this case.
There was no argument below regarding the paragraph that said, if you have a
The
problem
conditional
with any
thing?
of this, let us know.
No. Thank you very much.
Your Honors,
Ms.
hopefully I have...
Help me reconcile Clampett and Burge and Cervalas. You know, in Clampett, the Supreme Court said that the presumption of rear-end driver negligence applied, even though there was evidence that the plaintiff had slammed on its brakes, and they said, slamming on your brakes isn't enough unless it's totally unexpected. Then you have Burge, which says, if there's evidence of comparative negligence, the presumption goes away. And but they don't say Clampett's wrong. They just say we didn't address everything in Clampett. I mean, how do you reconcile the two? I mean, what happens if you have a sudden stop, but it's not unexpected?
Right, and you asked that question of plaintiff's counsel about whether or not there's any evidence of comparative negligence, that the rear driver presumption would not apply. And the answer is you're correct. It would not apply, and Burge expressly so states.
But Clampett's still out there. Clampett says a sudden stop that isn't an unexpected sudden stop, that a sudden stop alone does not do away with the presumption. So how do you reconcile those?
I may not remember this accurately. I believe it's footnote number 18 in Burge, where the Supreme Court discusses Clampett. Somewhere along there, one of the footnotes extensively addresses that and says to the extent that Clampett could be read in that way, that is not the way that they intended. The Supreme Court says they did not intend to create a special class of tort action in a rear-end driver situation, and that they would not impose the rear driver presumption if there is any comparative negligence. And the Supreme Court itself reconciled it because they recognized that Clampett could be read too broadly. Clampett no longer applies. This case before you today is not necessarily a sudden stop case. There's also this evidence about the plaintiff entering into the median or not entering into the median. So we're not just talking sudden stop. And when you look at the actual facts in the various cases that defendant has relied upon for bursting the bubble on the rear-end presumption, many of them have to do with things other than sudden stop. People talking on cell phones, people making merges from one lane to the other, and it's not just sudden stops that apply. And if I could just make one point before I sit down, on pages 994 through 96 of the trial transcript, defense counsel makes the express objection to the Hertz instruction, saying that it was designed only to make the defendant responsible for malpractice, and objected to the instruction on the correct basis. The only other thing I would say is that the admission which supposedly was made by defendant in his deposition that if he had been traveling further back, the accident would not have happened, that follows the question where the defendant was asked, is there anything you could have done to avoid this accident? And the defendant answered, no. The plaintiff's following question is, well, what if you had been traveling further back? Could you have avoided the accident? And the defendant honestly answers, yes. It's for a jury to determine what inference to take from that testimony.
The question was actually, isn't it the responsibility of the driver to follow at a safe distance to avoid an accident? That was more.
So there's a series of 3 cases, all on page 5397, where first he's asked, is there anything you could do to avoid the accident? He says, no. He says, well, could you have been traveling further back and then you would have stopped in time? He says, yes. And then the plaintiff has this long narrative about, well, isn't it your responsibility and don't you think that, you have a duty to stay far back? And he says, yes. It's for a jury, not the trial judge, to determine what inference to draw from that line of questioning.
If a defendant said, yeah, we're doing 70 miles an hour and I was half a car length behind, can a judge decide as a matter of law that that's negligent?
No, the
You're
answers
saying that has
to
to go to
these
the
are
jury?
not, these are,
In my hypothetical, are you saying that has to go to the jury?
I'm saying these are not admissions that he caused the accident
That
100%.
was the question I had. You said it should go to the jury. I'm saying if cars, half a car length behind, it's 70 miles an hour, and then there's a collision, can the judge find as a matter of law that there was negligence on the part of the rear driver?
If that were the only fact, what I'm saying is the
Yes
judge.
or no?
Yes, if it was the only fact, but
So in this
the
case,
judge picked
in this
that
case, we
fact.
have 35 miles an hour, half to 1.5 car lengths. So can the judge make the decision as a matter of law?
At that point, if it was in a vacuum, that was the only fact, but it's not the only fact. You have the plaintiff perhaps moving in and out of the median, so it becomes a question that might actually require expert testimony to determine whether or not that was sufficient distance to avoid the accident if the plaintiff had committed to her turn into the median. Thank you, Your Honors.
All right, thank you.